Assalamu alaikum and welcome you all to day 5 of Practice to Pass F4 English Law. So in the last 4 days we have touched different areas of F4 and most importantly the one with the most important technical knowledge that you should know before attempting this paper. And we have talked about all the types of questions that examiner would be testing you with MCQs, MTQs, and today we are going to talk about some more technical area we are left with, and we'll do some more practice. So I hope my voice is clear. If anybody is experiencing any problem in voice, kindly let me know. You can type in the question box. Okay, so the voice is clear. Perfect. So, the next topic that we need to talk about is insolvency. So we have made up a company, we have made up the constitution, we have talked about the capital that could be raised, share capital, loan capital. We have talked about different officers, company secretary, director, and auditor. And we have talked about the rules regarding the meetings. Now let's talk about that how does a company comes to an end, liquidation of the company. So that is the next topic, liquidation of the company. First, we will discuss some technical aspects and then we will move on to the questions. So just a reminder, at any time you have any question, you can write it. Yeah, you can write it in the question box. Okay, students. The topic is liquidation. So, before moving on to liquidation, let's see what a solvent company is. What a solvent company is. Well, a solvent company is that company when it has enough assets to pay its liabilities. If a company has enough assets, excuse me, to pay its liabilities. So we say that this is a solvent company. This is a solvent company. And likewise, what would be an insolvent company? Insolvent company? Well, an insolvent company would be that company, well, which does not have enough assets. Enough assets to pay off its liabilities. So if you do not have enough assets to pay off the liabilities, then we say that you're an insolvent company. So what do we do when a company becomes insolvent? When you see that we do not have enough money or enough assets to pay our liabilities, well, we have two options. We have two options at that time. The company can go for these two options. Option number one is liquidation and option number two is administration. Liquidation and option number two is administration. So liquidation is a process where the company is wound up. So what do? We decide to wind up the company, to end the company, to dissolve the company if we do not have enough assets to pay off the liabilities. So one of the decisions that is taken is to wind up the company, or you can take up the decision to rescue the company. to give it one more chance to save the company. So we'll be talking about both of these things today, liquidation and administration. So let's talk about liquidation first. And to carry out liquidation, we need a liquidator. We need a liquidator. Well, liquidator, who is a liquidator? The person who carries out liquidation. The person who carries out liquidation. Well, how would he carry out the liquidation? Well, he will sell all the assets and liquidate all the assets and pay the liabilities priority wise. Pay off the liabilities priority wise. When you talk about liquidation, well, we have two types of liquidations. One of the liquidation is voluntary liquidation, when you decide to liquidate the company yourself, and one of the liquidation is compulsory liquidation. And voluntary liquidation is furthermore divided into two categories: members voluntary liquidation and creditors voluntary liquidation. Creditors voluntary liquidation. So there's one thing regarding members voluntary liquidation, and that is a member voluntary liquidation will only and only take place if the company is solvent. What is a solvent company? A company that has enough assets to pay its liabilities. You need to remember this rule. Member voluntary liquidation can only and only occur if the company is solvent. And if the company is insolvent, then creditor voluntary liquidation takes place. So technically, if you're doing member voluntary liquidation, the company is not in financial difficulties. So remember the rule, for a company to have member voluntary liquidation, it should be solvent, and for a company to have creditors voluntary liquidation, it should be insolvent. So that is the flow chart for liquidation. Liquidation, and the other option that you have is administration. We will talk about this option in a while. So these are the two options that you have when a company faces difficulties. Let's talk about them one by one. Member voluntary liquidation firstly. So members voluntary liquidation. Who initiates this liquidation? Of course, the members, the shareholders, or the members in the limited by guarantee company. So liquidation is when a company is dissolved and its affairs are wound up, and liquidator must be an authorized insolvency practitioner. Remember, the liquidator should be an authorized insolvency practitioner. So they have a duty to report once the liquidation is done. Once the company enters the liquidation, there should be no share dealings. Communication must state the company is in liquidation, and directors' power to manage ceases. The company does not have to be insolvent to be liquidated. Well, that is true for member voluntary liquidation. This is compulsory liquidation. We will talk about it in a while. Let's go to member voluntary liquidation. The company should be solvent for member voluntary liquidation, and a special resolution is passed. So how does member voluntary liquidation begin? Okay. A special resolution, we studied yesterday, 75% vote is passed by the members. Remember, at time, ordinary resolution also would do if your company's AOA says that. If a company's AOA provides that ordinary resolution can be used, you can use ordinary resolution as well. So special resolution, 75% vote is required. So when you decide that the company should be liquidated, a notice to the registrar should be sent in 14 days. In that meeting, a liquidator is appointed from the member side who would be carrying out the liquidation. A statement is made which shows that company is solvent, and it is known as declaration of solvency. This is a statement which should be declared by the company to prove that the company is solvent. And this statement should be given with proper due diligence, because if this statement is wrong, if this statement comes out to be fraudulent, wrong, this is a criminal offense regarding companies. We will talk about this offense in next chapter. And once the declaration of solvency is done, the liquidator carries out the liquidation by selling the assets, bringing them into most liquidated form, that is cash, and then paying them priority wise. After is done with the registration, he informs the company's house. Registrar is informed, and registrar would struck off the name of the company from the register of companies after 3 months. He will wait for 3 months and then he'll struck off the company's name. This is member voluntary liquidation. When the members decide to liquidate the company. What is creditors voluntary liquidation and who actually starts it? Well, logically, it is initiated by the creditors. Creditors demand the directors to call a meeting and pass a resolution to wind up the company. A meeting is called, of course, of the shareholders, and a special resolution is required. If a special resolution is passed, the creditors are informed that yes, the company has decided to wind up. Again, a notice is sent to the registrar in 14 days. Well, in creditor voluntary liquidation, members choose 5 people from their side, and then a meeting is called of creditors. The meeting should be called in 14 days, within 14 days, and then the creditors also decide on 5 members, and a liquidation committee is formed. Liquidation committee of 10 members is formed, headed by the liquidator from the creditor side. So here the liquidation committee carries out the liquidation, and once the company is wound up, the registrar at company's house is informed and the name of the company is removed from the company's register. Excuse me. So creditors are sitting at this much important position that if any company owes a creditor £750, the creditor can demand voluntary liquidation. For a creditor, and they can demand voluntary liquidation. So members voluntary liquidation versus creditor voluntary liquidation. So what is compulsory liquidation? So if the compulsory liquidation order is brought from the court. This is the order given by the court, and the court appoints the liquidator, and the liquidator from the court side is known as official receiver. So if the court sends an official receiver to liquidate a company, that is the compulsory liquidation order for that company. Well, one of the reason is that the creditor is demanded liquidation, the company is not paying them, creditor demanded liquidation, and a meeting is called and a special resolution is not passed. So if even if you were the creditor of the company and the resolution is not passed, you would ask the court to give the compulsory liquidation order. So this is one of the reasons. There are other reasons for compulsory liquidation as well, but one of the reason is this. Okay. So what other reasons could be there? There are actually 7 reasons. 7 reasons for compulsory liquidation, but you should know just 2 to 3 of them. So company is unable to pay its debt, as I just told you, reason number 1. When it is considered just and equitable to wind up the company by the members, or when a public limited company has traded without trading certificate and it is in the public interest to wind up the company. So you should know 2-3 reasons. So let's talk about the reasons. Let's just jot down the reason. Reason number 1, for example, unable to pay the creditor. So creditor can put the petition. Yes, creditor can take up the petition to the court, and the limit is that £750 should be owed to each creditor per creditor. £750. Another reason, you are a PLC and it is more than 1 year and you have not obtained trading certificates. So remember, a PLC is not allowed to trade without a trading certificate. So if you're a PLC, then there should be compulsory winding up orders from the court. Or it is just and equitable to wind up the company. There should be a reason to convince the court that this is just and equitable to wind up the company. For example, company has lost its objective. The company was formed for what objective? The objective is lost. Or there is no connection between the people. The connection between the people is lost. There is a deadlock between management and other people. Or for example, if it is a quasi partnership. We talked about quasi partnership in lifting the veil. Quasi partnership, when you're working like a company, but it actually is a partnership. When the veil is lifted, it is said that it is actually a partnership. So for any reasons, any one of the reason, a compulsory order is given from the court side and court sends an official receiver. That official receiver will come and sit in the company and would start the liquidation. So there are some immediate effects of official receiver. Immediate effects. You can see that official receiver becomes the liquidator. Liquidation is from the date of petition presented. Subsequent sale of assets are void. Legal proceedings are halted. Employees are dismissed and floating charges crystallizes. I will jot down these points here for you guys. Okay. So official receiver becomes the liquidator. Number 1. Liquidation date is the date of petition. For example, the petition was filed on 1st March and the decision was given on 28th March. So liquidation date would be 1st March. and all the transactions from 1st to 28th March, all the transactions related to assets and liabilities would be cancelled, would be considered void. If considered void, this is the effect number 3. All the employees are dismissed. All the employees are dismissed automatically. However, the liquidator may keep some employees to help him out in working of the company. And all the legal proceedings, any case against the company is stopped, is halted, and it is mentioned that the company, there is an official receiver from the court and company is going through compulsory liquidation. And lastly, all the floating charges crystallize. One of the reasons for crystallization was when an official receiver is appointed. So then the liquidation is started and receiver holds the meetings with the contributories, and official receiver must investigate the affairs, of course. He investigates the affair, and they may apply to the registrar for early resolution if assets do not cover their expenses. So they can apply to the registrar for early resolution, or they can continue and complete the liquidation. So this is what company liquidation is. Just an equitable ground, I told you already. Main purpose of the company is gone. Company is fought for some illegal purpose. Complete management deadlock or understanding between the members is lost. So this is compulsory liquidation. And in both the liquidation, the order of payment should be followed. What should be the order of payment? Who should receive first and who should receive later? Remember, the fixed charge holder takes the asset that is under a fixed charge. Nobody can stop him from taking that asset. So the first person is the fixed charge holder. So technically he would not come under the order of liquidation because he would just take away the asset. So the very first person to receive the amount, very firstly we would be deducting the liquidation expenses from the total assets. Who is paid next? Preferential creditors. And preferential creditors are employees. Employees, well, they are paid. If they have not received their pay from last 4 months, they are paid along with the holiday accrued pay, and it is subject to statutory maximum, that is pound 800 per employee. However, you need to pay them first, and then floating charge holders are paid, floating charge holders, and then unsecured creditors. Unsecured creditors, you have borrowed the money from them, but you have not created any charge, and they actually would rank equally. So they would get equal amount, and the amount is left, they would be told that the company is dissolved. It is unrecoverable now. After that, you would pay the interest that is due after the liquidation, and then the dividend that is already been declared. So if there's any amount left, the declared dividend is paid, and then members are paid. The last person to get the money is the shareholder. Preference shareholders, if they have any preferential claim, if we have given it in the AOA, but this is not the right given by law, but you can give this right to your preference shareholder that you will be paid first in the order of liquidation, and whatever is left, if anything is left, it goes to ordinary shareholders. And normally if the company is insolvent, nothing is left for the ordinary shareholder, and this is divided between the members. So this should be the order for liquidation, and this order should be followed when you are distributing the amount of liquidation. So these are all the things regarding liquidation. Let's have a look at some questions. In which of the following situations will the court order the compulsory liquidation of a company on just and equitable ground would be given? Where 50% of the members disagree with the action, when the main objective of the company cannot be achieved, where a company has failed to pay its creditor for 3 months. Okay, what do you think? Fail to pay the creditor for 3 months is a logic that is given. However, for just and equitable, the answer is you should come up with an answer in your mind before I tell you any answer. Yeah, the answer is B. B is the answer. So when is a company deemed to be unable to pay its debts for the purpose of a compulsory liquidation, where a creditor owed at least £250, £500 or £750? Well, the amount is £750. Much talked about, amount is £750. At which point does member voluntary liquidation commence? As soon as the member passes the necessary resolution, as soon as the registrar receives a copy of the resolution, as soon as the liquidator is appointed, or as soon as the director authorizes it after the resolution? Well, the answer is A, as soon as the necessary resolution is passed. Which of the following persons or bodies can file petition to court for a compulsory liquidation? The company itself, any creditor, any director. The company cannot go for compulsory liquidation. It should be the creditor. So these are the differences between compulsory and voluntary liquidation. So short break and the session resumes. Okay, welcome back, students. So, whenever the company is insolvent or in financial difficulties, the company's got two options: either to liquidate or go into administration. Or go into administration. Now, what is administration? Administration is an attempt to save the company, an attempt to rescue the company. One last attempt that if you can save the company, you should give it a try and save the company before going into liquidation. Before going into liquidation. It puts an insolvency practitioner in control of the company with a defined program for rescuing it from insolvency as going concern. So they want the company, they do not want the company to wind up, they want the company to be rescued as going concern. So this is the one last try that you do, and there are basically three scenarios, that three reasons why would anyone agree for administration. Well, number one, of course, the shareholders, directors, and all the officers excuse me, they're informed that the company would be rescued as going concern, and the company would operate as usual, and you'll be part of the company. So you just need to wait a little bit just for the last attempt to save the company. Or it is said to the creditors that if the administration is successful, it would give them better result. If the company is wound up right now, the creditors might not be able to get all the money that the company has to pay them. And of course, it would help to realize the company assets, the property of the company in a better way. Better way. So, who appoints the administrator? Who is an administrator? Administrator would carry out administration, and he is again an insolvency practitioner like you need for liquidation. So who can appoint the administrator to carry out the liquidation? Well, the court can appoint the administration if a petition is filed by any creditor of the company, by any director of the company, or by the company itself, means the member of the company itself. Who else can appoint the administrator and start the administration? Well, a floating charge holder. Floating charge holder has the right, other than court as well, he can appoint the administration and bring the company under administration, or the company itself and its directors. They can even, without court order, start the administration. So administration is always and always done when a company is insolvent, because that is an extreme step that is taken, and It is always and always done when the company is insolvent, unable to cover its debts with the assets. So an administrator is appointed, and as soon as the administrator is appointed, there are certain effects, certain consequences of the appointment of the administrator. Well, all the rights of creditors are for a short time, for the time of administrator, they are suspended. All the charges, noting charges, they are suspended for the time of administration. You cannot enforce the charge. No enforcement of any sort of payment or charges is allowed during administration. If you have any outstanding petition for compulsory winding up of the company, of liquidation, it is also stopped. It is also stopped or halted, and it is announced that company is going in administration. These are both mutually exclusive. If administration is happening, liquidation is not happening at that time. So you cannot even resolve to wind up, and director continues the office. Directors continues to stay in office, but their powers are basically taken away from them, and their powers are suspended, and all the powers of management of the company are given to the administrator. All the powers are suspended. So what would be the span of administration? Can it go on and on? No. You need to bring up a proposal in 8 weeks, and the proposal would say either that the company would be rescued or no. You'll have 8 weeks to bring up a proposal, and the proposal would either say that yes, the company can be rescued, or no, the company cannot be rescued. If it says no, the company goes into liquidation automatically. So if you say that the proposal says yes, so you have 12 months to rescue the company. You'll have 12 months to rescue the company, and if after 12 months the company is not saved, you would go into the liquidation again. So this is all about administration, effects of the administration. Moratorium is a freeze, commences on creditors, items which are fixed or charge holder cannot be basically used, and advantages, company is not dissolved, company can come back to going concern. Administrative duties of all the company, and they need to send the notice to the company and creditor and registrar, and they must consider the statement of affairs and proposal. As I told you, you can say yes, the company cannot be saved, or no, the company can yes, the company can be saved, or no, the company cannot be saved. They have all the powers that are given to the management, they are given to the administrator, and it ends after 12 months. So this is what administration is all about. So which of the following parties may apply to the court for compulsory liquidation of a company? The company's auditor, if they deem it necessary. The For compulsory liquidation, the creditor who is owed more than 750 and who sent the company a written demand for over 3 weeks. Remember, 3 weeks is the time, and if the company does not respond in 3 weeks, the creditor can go for compulsory liquidation. And the registrar of company, if they have not received copies of the company last 3 statements. The answer is B. Which of the following names is given to the person in charge of voluntary liquidation of a company? Receiver, chargee, liquidator, administrator. Liquidator. Liquidator is the would carry out voluntary liquidation. Which of the following parties has their interest paid first out of liquidated company's assets? The liquidator, floating charge holder, employees, those owed deferred debts like interest. Well, as I told you, the answer is liquidator. Which of the following parties may appoint an administrator without a court order? A floating charge holder, fixed charge holder, and unsecured creditor. Well, only the floating charge holder from these. Floating charge holder can appoint administrator without court order. In the context of corporate insolvency, which of the following describes the purpose of administration? To allow the company to pay its debts before it is liquidated, to prevent legal actions being taken against it, to an attempt to rescue the company as going concern. So by definition, C is the answer. Which two of the following will end an administration period? After 12 months have elapsed since the administration commenced, of course, this is going to end. The success of administration, yes, even before 12 months, the administration can succeed and you can end administration. So answer is A and B. Only A and B will end the administration. So these are the situations under which it is said that the company could either be wound up or the company could go under administration. So then so the next topic is regarding the certain fraudulent behaviors which are not allowed to companies and which would be basically mostly considered a criminal offense. Fraudulent behavior which the companies normally show and which they are not allowed to show, and if they show this behavior they'll have to suffer penalty. So let's begin with the very first issue, and that is insider dealing. That is the first offense. This chapter is important. These areas, criminal offense when it comes to MTQs, fraudulent trading, and the first offense is insider dealing. Insider dealing. What is insider dealing? What is the process of insider dealing? It is a process where a prospective purchaser prospective purchaser. The purchaser we think can buy what? Where a prospective purchaser could gain information. Which information? That information of the company which is related to shares or securities. Shares or securities before it was made public. So what is happening? There is a prospective purchaser, for example, Mr. A. He gets the information about the shares or securities, and that information was not disclosed by the company, and he uses this information which information regarding the shares of the company to take advantage and to make profit. So when this sort of profit is made, it is said that it is insider dealing. There was an insider, a person from the company, a person related to the company, or a person by profession has any information. It could be employee, it could be director, or it could be a person of any profession, for example, auditor. They get the information and the information is not yet made public, and they disclose it to somebody. And who is that somebody? A prospective purchaser, and that purchaser uses that information to make profit, to do dealing in that shares, dealing in the shares of securities and gain profit. This is insider dealing. And a person from inside discloses this information to outside, and the person uses that information to make profit. Right? So what are the offenses under insider dealing? So a person with the information, the insider, a person with the information, that person is an insider, will that person, number one, the person himself, or they deal in price affected securities, which are shares themselves. They can even deal with the securities themselves, and they are liable under the offense of insider dealing, or they encourage someone, another person, to do so, to deal. Either they deal themselves, or they encourage someone else to deal, or they disclose the information to somebody who should not be having that information until and unless the company is making it public. The company is making it public. So you would be liable for the offense of insider dealing if you are involved in any of these three. And you can get away, you can say in your defense that I had reasonable ground to believe that company has already made public I thought the company has made public the information already. Or you can say that, yes, I dealt with the securities, but I would deal in the security anyways. I was about to sell the shares anyways, or I was about to buy the shares anyways. Or you can say that I have not gained any profit. Why would you say that I have done insider dealing? So certain defenses are also available for insider dealing. So price sensitive and specific securities, dealing and defenses could be not expecting a profit, having reasonable belief that the information was already public, or you would act like that anyways. So these are the defenses. Who's an insider, director, employee, shareholder, or any other person through employment. Price sensitive issues. So this is what the offense of insider dealing is. And if you're accused of insider dealing, if you have done insider dealing, what could be the consequence? What could be the penalties for the offense? Well, if it is a summary offense, as you know, summary is a minor offense. If it is a summary offense, you would have to pay a limited amount of fine or 6 months imprisonment. And if it is an indictable offense, as you all know, indictable offense, we have studied them in English legal system, court system, it's a major offense. So you would be liable for unlimited fine and or 7 years imprisonment. 7-year imprisonment. So this is all about insider dealing. And other offense is market abuse. Another offense in this area is market abuse. It is normally considered a civil offense. Market abuse. So what is market abuse? A behavior that satisfies one or more prescribed conditions that are regarded as failure on the part of person concerned to observe the standard of behavior reasonably expected of a person in their position in relation to the market. In relation to the market. So let's see. When we say market, a place where we do dealings, where company trades, where a company trades. So if someone does something that would basically distort the image of the market, distort the image, distort means change the image, alter the image, or completely vanishes the good image of the market, of your own product, where people would come and deal, buy your product, sell your product. So that would be market abuse. That would be market abuse. And such behaviors would come under market abuse. So from that behavior, you have distorted the image of the market, a place where people would come to buy your product. And that behaviors are, there are basically 7 behaviors through which you can do that. Number 1 is insider dealing. Insider dealing, when you are dealing in securities, price sensitive, price affected securities, and company has not yet made it public, and you're using the information, you're dealing in the securities and making profit or encouraging somebody else, or improper disclosure, again under insider dealing, improper disclosure, when you are not required to disclose, when the company has not disclosed, made public information yet, and you are doing it, or misuse of the information, say for example to gain profit. Say for example to gain profit. What could be the other conditions? Manipulating transactions. Manipulating transactions to give a wrong image, and that is you basically mislead the customer regarding the position of the market, and that is basically done. One of the prime example is that when a company or orders a broker, or company buys its own shares, so that an image is given that the company's performance is very good, and that is why people are buying these shares. Actually, those are your own investors, and when they buy that much shares from the stock exchange, people would get the impression that the company is doing really well. Let's just invest in this company, and the next morning, when people would start investing in the company, you can sell the shares. So basically, you're using a transaction to manipulate the image. By a simple transaction, you can do that, or manipulating the devices, manipulating the image using a device. Devices. You can say that we have invested in so many devices, and those would be fictitious devices, and they do not exist. Fictitious investments or the devices, and they do not actually exist. Some of the other factors would be dissemination of information. Dissemination is when you pass on the information and when you spread the information in the market. Spread the information in the market. About different investments, and however, and you have not done those investments, you're just spreading the false information in the market. That would also affect the image of your market. Or distortion or misleading behavior, and that would be a sum up of all the behaviors. For example, when you give a false impression regarding the demand, and you create false demand, and then because of that you would create false shortage, and because of the demand and supply and price rule, the prices would go up. So this is something that is not true, that is not good to do, and that would distort the image. So what would be the consequence? Penalties for market abuse? Well, unlimited fine, and basically public reprimand by civil law. It is actually a civil wrong. So this is actually a civil wrong. So reprimand is basically an expression of disapproval. Public would say that we disapprove this behavior, so that would affect the reputation as well. Disapproval from the public side. That is market abuse. You can say that devices, information, manipulating transactions, and all these things. What type of action can fraudulent trading give rise to? Well, we'll talk about fraudulent trading in a while. What type of law is market abuse a breach of? Civil law. Let's take a small break of 5 minutes. Okay, welcome back to the session, students. So, we talked about certain offenses. Let's talk about another one, and that is money laundering. You're aware of this offense. You've done it in F1 as well. Money laundering. So, what are the technical aspects that you should know regarding money laundering? Well, this is the process by which it's an attempt to make the proceeds of crime appear respectable. And you are hiding the source basically. So what is money laundering? Process by which proceeds from criminal activities and they are made to appear from a legitimate source, from a legal source. So we try to hide the source of illegal money, excuse me, money from criminal offenses. And it is done in 3 layers, 3 phases. Number 1 is placement, when you actually initial deposits, when you deposit the amount into initial small packets, disposal to some illegal activity, and then you move on to layering, and in layering basically you transfer the money from account to account or business to business, and they are involved in complex transaction, uh, just to give a false impression and to an outsider, and the transactions are complex enough that they cannot be traced as you move the money from account to account and uh, from business to business. And the final step is integration. Well, that is culmination of the previous procedure, and in integration, after having been layered, the money has the appearance of legitimate funds. The money is integrated, is culminated into the market, and so that it appears as a legal business. And now when the monies are going to come back to your account, they are going to appear, and they're actually coming through legal transactions, and this is how it is all done, and it is all concealed, that finally there would be legal transaction from a legal business and from where you're getting the money. So basically you have achieved the purpose of hiding the source, of concealing the proceeds from a illegal criminal activity. There are 3 phases. We need to remember: placement, layering, and integration. Placement, layering, and integration. So what are the offenses under money laundering? The offenses under money laundering is you doing the money laundering yourself, which would amount to the imprisonment of 14 years if you're found guilty of that. And failure to report is another offense. Your company, somebody in your company, somebody you know is guilty of money laundering and you have not reported about him, so you would be penalized for 5 years with unlimited fine. Unlimited fine. So just a reminder, if you have any question, put that on the question bar. Okay, and the third offense is tipping off. Now, what is tipping off? Tipping off is like when the authorities, they are coming, authorities are coming for a money launderer, and or agencies are coming, but you indicate that person, but you indicate that person that they're coming to get you, and if there's any sort of indication from your side, you would be liable for the offense of tipping off, and that would again lead to a penalty of 5 years imprisonment and unlimited fine. That is money laundering. So another offense, bribery, ruled by Bribery Act. Bribery is another offense, and there are generally 4 offenses related to bribery. Giving money for some illegal purpose to get the illegal work done, or accepting money, or bribing a foreign public officer, an FPO, a foreign public officer, to gain some advantage, to gain some undue advantage. You can bribe an FPO for a business advantage. For example, you want to complete a transaction and you're bribing a foreign public officer. For example, you are in default, and in default to provision of certain document to the public officer and to the registrar, and you basically give them some gifts, give them some money, and so that they should not bring up the topic and they should not penalize you for the basically the default in the provision of documents. And corporate failure to prevent bribery, to prevent bribery. So if you're working for a corporation and you want to prevent bribery, you're working for a corporation and you are responsible for strategic management of a company, you should place certain controls. There should be certain controls in place so that bribery should not occur in an organization. So if you're not doing that, you are liable for the corporate failure to prevent the bribery. This is an offense related to company. These are the 3 offenses related to individual. So penalty for an individual would be a 10 years imprisonment if you're found guilty, and penalty for a company if they fail to provide certain controls would be unlimited fine. However, this unlimited fine would bring big reputational damage. A big reputational damage. If you don't have enough controls and the bribery is taking place in the country, so the prosecutor case is taken up in the criminal court. So that would bring, although the penalty is just some unlimited fine, but the case that is going in the criminal court would bring reputational damage, would give rise to reputational risk. Well, for that, you can refer to DPA. Now, what is DPA? Deferred Prosecution Agreement. Deferred Prosecution Agreement. So, bribery is taking place in the company and you have not enough control, so a prosecutor case brings up the case in criminal court. But company can ask the person, company can ask for paying the fine and settle the matter outside the course, outside court settlement. Why? Because if it is going to go to the court, the company says to the prosecutor that we will give you settlement to you, but just don't take the case to the court. So this would allow commercial organizations to save their image. To save the image and paying the fine, but without being prosecuted. So did you get it? Without being prosecuted. That is DPA, Deferred Prosecution Agreement. Deferred Prosecution Agreement. To save the company from reputational damage. So bribing another person, being bribed, giving money or taking money, bribing an FPO. FPO is anyone holding a legislative, administrative or judicial position in a country. Corporate failure to prevent the bribery. Not adequate controls. So the next three offenses, DOS for declaration of solvency. These are related to the offenses related to insolvency. The other three offenses, after all these, are related to insolvency. And one of the offenses, declaration of solvency, and that is untrue. That is not true. You have said that the company is solvent, but the company is not solvent. It is a criminal offense. It is a criminal offense regarding the companies, and you would be penalized for that, for doing this. Unlimited fine and imprisonment. Another offense is fraudulent trading. Another offense is fraudulent trading. Fraudulent is from fraud, fraudulent trading. When your intention is to defraud the customer, defraud the creditors. So once the company goes into liquidation, there would be somebody, they do not know that the company is liquidation, and you are doing transactions with them. It could give rise to civil as well as criminal liabilities. So civil as well as criminal offense. So fraudulent trading, the business of a company is found to have been carried out with the intention to defraud the creditors for any fraudulent purpose. Directors are liable for company debts under the civil law or punishment under the criminal law. Civil law proceedings and criminal law proceedings. So if any director is found guilty of doing that, and director is knowingly a party to this transaction, the director knows that this transaction is happening. So what could be the penalties? What could be the consequence of such arrangement? Well, the person or the director who is liable will contribute to the assets, asked to contribute to the assets. A director can be disqualified under the Companies Director Disqualification Act for 15 years. We have studied that before in disqualification of the directors. And if is guilty for criminal law, that leads to the imprisonment, and that is fine and imprisonment, which could go to 10 years imprisonment. Wrongful trading. Another offense, directors of an insolvent company knew or should have known that insolvent liquidation could not be avoided and took insufficient steps to minimize the losses to creditors. So, wrongful trading. What is wrongful trading now? Wrongful trading is again when the company is in liquidation. The liquidation cannot be avoided, but the directors they continue trading, but with the intention, not with the fraudulent intention to defraud the creditor, but with the intention to make companies position better. But they should know that the insolvency or liquidation cannot be avoided now, so they should not be doing this. They're doing this, they're doing it wrong. And if they do that, the consequence would be disqualification. Directors disqualification under Company Director Disqualification Act, and for 15 years, plus the directors would have to make contribution to the assets for the losses. So in fraudulent trading, the directors know, they are knowingly parties that they are doing fraud, defrauding the creditors, and then they'll be liable for criminal or civil offense. Well, in wrongful trading, directors just wanted to make the company's position better. So if they know it or they do not know it, well, they would be liable under this act. Knowingly party is not a condition for wrongful trading. So directors are liable to contribute to the company. It is not a criminal offense because the intention is not bad. It is not a criminal offense. So let's have a look at some questions. Which of the following is a corporate bribery offense? Bribing an individual, receiving a bribe, bribing an FPO. These are individual offenses. Failure to prevent bribery, that is corporate, that is company bribery offense. Okay, so next question. Which of the following would not be a relevant body in relation to the failure to prevent the criminal facilitation of criminal tax evasion? Which is not a relevant body? A non-UK company, a general partnership, or a sole? A failure to prevent the criminal facilitation of criminal tax evasion. You're going for tax evasion, uh, which is illegal, and a non-UK company. Well, the answer is a non-UK company. UK for a UK company, you can go for the criminal facilitation of tax evasion. Well, other offences: managing while disqualified, Phoenix company, a fake company, fraud and deception during the performance of the company, defrauding the creditors during the management of the company, misconduct, falsification of company books and admissions. So which of the following is a defense to charge of insider dealing? The individual had no expectation of profit. The individual had reasonable grounds to believe that the information was about to be published. The individual had reasonable grounds to believe that action was in the public interest. The individual was not seeking to profit from the transaction personally. Well, the answer is that individual had reasonable grounds to believe that the information was about to be published. Which of the following statements is correct? An action for wrongful can be brought regardless of whether the company is solvent or not, against directors and shadow directors only. Well, the company has to be insolvent for wrongful, and the action could be brought against directors and shadow directors. The answer is B, two only. So these are offences related to insolvency, wrongful trading, and fraudulent trading. Which two of the following are offences related to money laundering? Failure to report, placement, integration, and tipping off. So if it says 2, A and D. Which of the following statements in relation to offence of bribery is correct? Bribery is a tort. Bribery can only be committed in the UK. It is an offence for a corporation to fail to prevent bribery. C is the answer. Bribery is not a tort, not a civil wrong. It is a criminal wrong. Which of the following must be proved to win a case of fraudulent trading under insolvency? Fraud was due to negligence, fraud was intended, fraud was profitable, fraud was preventable. Intended, knowingly, party was knowing that the party was doing the fraud. Which two of the following are offences that are connected with the insolvency of a company? Wrongful, market abuse, declaration of solvency, or bribery? Wrongful and DOS. A and C. So these were all the technical areas for F4 English law, and we have talked about all the important areas. You should give them proper revision before sitting into the paper, and we have talked about certain MCQs. Well, we'll take a break of 10 minutes and then we'll talk about certain MTQs. We started off MTQs yesterday, but we'll do some more MTQ practice today, and I'll be taking some of your questions. So the session would resume at 11:50. See you on the other side. Okay, students, welcome back to the session. If you have any queries, you can post them down in the question box. So yesterday we discussed some of the MTQs, and as I told you, 30% of your paper would be MTQs, and you get 5 MTQs worth 6 marks each, and you won't be asked to type anything. All you have to is to choose between the MCQ. There will be certain options and you have to choose between the options. So let's just head towards the MTQ session. So, so we have done, I guess, 5 MCQs. Well, let's talk about MCQ number 6. Okay, what does MCQ number 6 tells us? Okay, have a look. Riz is considering incorporating a public limited company. He is keen to ensure that the company is funded correctly but not excessively, and is aware that the Companies Act includes a number of rules concerning the share capital. He has been advised to consider the following terms in connection with share capital and is seeking your advice: issued share capital, paid up share capital, called up share capital, and authorized share capital. So, which of the following concerns the number of shares held by the shareholders? The number of shares the already shareholders have. Issued share capital, paid up, called up, or authorized. The answer is issued share capital. Which of the following concerns the amount of money a company has received for the shares held by the shareholder? The money that company has already received. Well, the answer is paid up capital. Which of the following correctly describes the minimum amount of paid-up share capital that Riz company must have? Since it's a PLC, the minimum amount is 50,000. 50,000. So this was an MTQ from share capital. This was an MTQ from share capital. Okay. MTQ number 7. C is a director of D PLC, while Kaz is a director of Dull PLC, but she also carries out her own business as a wholesale supplier of specialist matter under the name of E Limited. So C is a director DPLC, but she has also her own business with the name of E Limited. Okay. Last year, DPLC entered into a contract to buy a large consignment of metal from E Limited. C attended the board meeting that approved the contract and voted in favor of it without revealing any kind of link with E Limited. So, E has been a supplier to DPLC, and in the meeting where it was decided that we will be buying from E Limited, well, C was in that meeting and C did not tell that C has any link with E Limited during that meeting. Which of the following describes a director's statutory duty? Duties created under common law principles of agency. Duties created by the Parliament under the Companies Act. Duties created under the terms of a director's service contract, or duties created under the UK Corporate Governance Act. The statute, Parliament. Parliament under the Companies Act. B is the answer. Identify whether CAS has breached any of these duties. Promote the success of the company. Not breached. He has not breached this duty. Duty to exercise independent judgment. There was no such kind of any judgment, so not breached. Duty to declare interest in proposed transaction. Yes. He was required to declare the interest at the meeting. He did not. Declaration of interest in the existing transaction. Well, that is also breached. He was sitting in the meeting when the transaction was proposed, and even in an existing transaction, you're supposed to declare the interest. So both of these duties are breached. So both of these duties are breached. So another MTQ. J Limited was formed by two brothers, S and L, who are the company's only shareholders and directors. The company was very successful and has made good profits in every year of trading. However, recently the two brothers have fallen out over some matters in their personal lives and they are no longer talking to each other. This argument and the resulting lack of trust between S&L has made running of the company almost impossible and business is suffering a consequence. So, S would like to have the company liquidated and is seeking advice. Which of the following parties instigates a creditor voluntary liquidation? Is it done by the directors, or is it done by the members, or the creditors, or official receiver? Well, actually, it starts by the directors at the request of the creditor. In regards to J Limited, identify whether the following statements are true or false. S will need the agreement of L to instigate a member voluntary liquidation. That is true. Because if S is going to go for it, it would be 50% vote. You need 75% voting for that. So that is true. S will need the agreement of L to instigate a compulsory liquidation. No, that is false. It can bring compulsory liquidation on just and equitable ground. A court is likely to order a just and equitable winding of J Limited. That is true. An insolvency practitioner would oversee a compulsory liquidation of J Limited. It would not be overseen by an insolvency practitioner. It, compulsory liquidation is headed by official receiver, so that is false. So all the MTQs are there in the handout section, and you have handouts available for all the 5 days classes and these MTQs. So this was another MTQ, what 6 mark. So see, MTQs are not that much difficult. All you have to do is to choose an appropriate answer relevant to the scenario. So you need to keep just 7 to 8 minutes intact for per MTQ. You should do that. Do good time management in your paper. Keep 7 to 8 minutes per MTQ. Okay. E has been employed by Flash Limited for the past 20 years. During that time, he has also invested in the company in the form of shares and debentures. E owns 5,000 ordinary share and of £1 nominal value and are fully paid. Debentures to the value of 5,000, which are fixed charge debenture against the land on which the factory is built. And in April, it was announced that F Limited was insolvent and owed considerable amounts of money to trade creditors. However, the employee did receive half their contracted wages. In E's case, this amount to 2,000. Well, let's see. Question number 1. So Earl is an employee as well as a shareholder as well as a debenture holder of a fixed charge. If Flash Limited is liquidated, which type of creditor would Earl be in respect of the remaining half of his wages? For half of his wages, he would be a preferential creditor. Unpaid wages, he would be a preferential creditor. That would be up to a statutory maximum of 800 though. If Flash Limited is liquidated, how much of the company's debt will E be liable? If F Limited is liquidated, how much of the company's debt will E be liable to repay? None. 5,000, the shares only. 10,000, the debentures only. And 12,000, the share, the debenture and his wages. Well, company is liable to pay none because it's a limited liability company. So there is nothing in called up share capital. Had there been something in called up share capital, that amount would have been written over here and that would have been an appropriate answer. But right now there's nothing in called up. So he has already paid everything. So he's not liable to pay more because it is limited liability concept under companies. Answer is none. A. Assuming no insolvency proceedings have commenced, which of the following statement is correct in regard to E's fixed charge over the land? E may appoint a receiver of the land and order its sale. E can demand immediate repayment of what is owed. E may appoint an administrator of the company without reference to the court. Well, E is a fixed charge holder. Fixed charge holder cannot go for administrator, so C is not the answer. E may request the just and equitable winding up of the company. No. Well, the answer is A. He can appoint a receiver. He can appoint a receiver and ask for the sale of land and ask for the specific order. So let's move on to the last MTQ. Well, G and H are members of the board of directors of each PLC. So this is huge PLC. G and H directors, huge PLC. G also controls a private limited company implemented through which he operates a management consultancy business. He also owns all the shares in Jet Limited, through which he conducts an investment business. So Jet and I Limited, two companies controlled by G is I Limited and Jet Limited, two companies controlled by G. So what happens? When G learns that Huge PLC is going to make a takeover bid for COP PLC, he arranges for Jet PLC to buy a large number of shares in COP PLC. Well, Huge Limited is about to buy a company, takeover bid for COP PLC. And G knows that, and G arranges, G arranges Jet PLC. G arranges Jet PLC to buy all the shares because he knows that when Huge is going to buy Copil, the share price is going to up and he's going to benefit. And on the stock exchange, on which it makes a large profit when it sells them after the takeover bid is announced. He then arranges for Jet PLC to transfer for the profit to I Limited as the charge for supposed consultancy work. Moreover, he said that when we'll get the profit from here, we will move it to I Limited and we'll say that the fake consultancy work has been done. The money is then transferred to Greg through the declaration of dividend. And finally, it's going to come to account of G through dividend paid by I Limited. So this is how the money is being moved. H learns of Greg's action and tells him that she will be reporting him to the authorities because she believes that he is guilty of money laundering. However, she has decided not to report him for the insider dealing offense. Okay, so the question, have a look. Dealing in which of the following securities is covered by insider dealing legislation? Shares and associated derivatives, debt securities and warranties, shares and associated derivatives only, shares and associated derivatives and debt securities only, debt securities and warranties. So answer is A, all the price affected securities. Answer is A. And indicate whether the following parties have committed an offense in respect of insider dealing and money laundering. So Greg has committed insider dealing as well as money laundering, both. H has committed the offence of failure to report on money laundering. So this was F4 English law for all you people, and we have talked about, we have done so many MCQs regarding the relevant areas. You need to do the practice of take any textbook. You can take any textbook. It could be BPP textbook, it could be Kaplan, it could be Becker's. Follow any one textbook. Follow these notes for revision and follow any kit. So now you have an understanding that how your paper would look like and what sort of questions would be there, and you will be handling the papers good enough now, the questions. So if you have any question, you can write down in the question box. For any queries, an email ID has been provided. You can contact on that email ID. So we have discussed 100% of the chapters and all the important technical areas. I've revised those areas for people. Well, you need to download the books for yourself. It is impossible for us to send them here. You need to download the books. I have mentioned the names of the publishers for you. Gaurav Shahi and yes, Wahid. Hello. What is your question? If you have any queries regarding F4, you can post your queries over here. Well, all the soft copies, they are available in the handout section. You can refer to handout section. Yes, all the notes and all the notes and all the questions, they are available in the handout section. You can save them from here. An email ID would be provided for any future reference, future contact, future queries regarding F4. And right now, there's no WhatsApp group. You'll be informed if one would be created. Right now, for future contact, future references, email ID has been provided. So what you required is to go through any text. Well, Siana, Pasha, I have discussed all the important areas. starting from the English legal system to contract, tort, employment, agency, partnership, and company. We have touched all the important areas. You need to focus on these areas. You need to focus on these areas, the areas that I've already touched. These are really important technical areas. You're welcome, Wahid. So if there are any more questions, just feel free to ask. Get hold of a textbook and go through all the technical areas, and now you have the understanding that there will be certain MCQs and certain MTQs. Now you are familiar with MTQs, and how the examiner would be testing you in MTQs. It would be from different areas. You can get a question of MTQ from a contract. You can get a question from MTQ from fraudulent behavior, the last chapter. You can get a question from employment and all these areas. So for preparation ideas in short period, well, you can go through all these slides that I mentioned over here. These are really good for summary, and you can revise all the information given in these slides. You can learn them, and you can go and attempt MCQ question and MTQ question. So whatever material that I've provided you in these slides, well, these are really helpful, and you can go one slide one day and you'll be done in 5 days. You'll be done in 5 days. And get hold of a kit and start doing that kit. The kit has a lot more practice questions in it. We couldn't do that because of time shortage. So I try to do maximum practice with you people, and we have discussed MTQs as well. So Harshit, there's no WhatsApp group. So far, for any queries, future queries, you need to put an email on the email ID that has been provided. Well, Sianat Pasha is saying, do we need to remember all the case scenarios? No, you don't. You do not need to remember the any cases, any names of the case references or dates, and you can just have a general idea for your understanding. The examiner would not be referring to any particular case in your paper. You should have general ideas of certain cases, especially in contract law. You're not required to remember the names in the cases or the dates in the cases or the exact facts. You should just have an idea what the case is about and what the decision was. Hope that answered the questions. So this is all about F4 English law, and for further queries, uh, you can contact on the email ID that has been provided. All the recordings are available. And what was the question? Well, Hasib, the videos are working fine. We need to check with your connection. All the videos are working fine, and all the videos of last 5 days, they have been uploaded, and you can find the copy in the handouts section of all the handouts. So thank you so much, everybody, and it was pleasure um, guiding you all, and hope you get really good marks in F4. And this is all from our side. So signing off with a note of good luck, and enjoy the rest of the day. Thank you. I love this.